So here we are, folks. All we're hearing about is Toys R Us is gone, and the employees are asking for some type of severance since the executives get bonuses. And unfortunately, the real world works where Bain Capital and Bernardo Realty and KKR, they get paid and everybody else gets screwed. Nobody's paid attention to the fact that the way Toys R Us got owned by Bain Capital is, first of all, Goldman Sachs, Bain Capital, and Thomas Lee Partners and Mitt Romney ripped off Mattel for $4 billion by merging the Lettering Company through Morris Nichols Sarson Tunnel, the M&AT law firm, into Mattel. The books were cooked, right? There was an instant $4 billion loss, and Mattel was losing millions of dollars a day. So the end result is that Mattel had to give away the Learning Company for free to Gore's Technology Group. Now, that was in 1999, and at the same time in 1999, Goldman Sachs took eToys public. The stock went for, arguments 70, 78. I was the CEO, court appointed, ran the company as a liquidation consultant during the bankruptcy. And the price per share that we saw on the paperwork was as high as $85. But Goldman Sachs gave eToys less than $20 per share. And a classic pump and dump stock fraud spinning scheme where they give shares to select handpicks, and then those handpicks get a windfall profit that they spend half the profit back to Goldman Sachs and some type of fee structure. The New York Times reported on this in March 2013 by Joe Nasir, called Rigging the IPO Game. It should have been Rigging the eToys IPO Game. After the New York Supreme Court of Appeals came out and said that we could sue Goldman Sachs. But there was another scheme going afoot. M&AT was my attorney and eToys' attorney, and M&AT did not disclose the fact that it was also Bain Capital and Goldman Sachs attorney. Now, I got M&AT confess in 2005 that it was Goldman Sachs attorney, but they had an ace in the hole. The U.S. attorney, Combe Connolly, was an M&AT partner. So Combe Connolly and his assistant U.S. attorney, Ellen Slight, said that there was no case. There was nothing wrong. They don't have the right to do that. The Delaware U.S. Attorney's Office was supposed to recuse themselves, and we were supposed to get the public integrity section involved in the Mattel and the eToys case. Because they've done overt acts of obstruction and destruction of evidence to constantly keep the case from being investigated and prosecuted, the end result is that there's no statute of limitations. Now, first of all, they kept the bankruptcy case open for 15 years. eToys filed in March 2001 and closed in January 2015. So the statute of limitations is 5 years after the bankruptcy case is closed. They kept it open, hoping that Romney would become president and they could control the Department of Justice and wipe everything away. Paul Traub is Frank Nitti. Morris Nichols is another Frank Nitti of the case, where Gus Capone is Goldman Sachs, Bain Capital, Mitt Romney. And M&AT and Paul Traub, M&AT was debtor's counsel, but had secret relationships with Bain, KB, Goldman Sachs. And Paul Traub worked for Barry Gold, and Barry Gold worked for Michael Glazer. Michael Glazer worked under Mitt Romney at Stage Store's bankruptcy. And what they did was, Stage Store filed bankruptcy in 2000. They all sneak over to eToys and lie and say that they have no relationship with each other. And they deliberately killed a public company because it wasn't insolvent. And that's a whole nother story together. But they lied about the insolvency. What they did was, eToys had eToys, Baby Center, PMJ Kids, on and on, different domain names. So when Mattel filed a $10 million claim against eToys, it filed it against eToys, it filed it against PMJ Kids, against Babysitter, on and on and on. And so they created a phony debt structure of $290 million. The reason why they had to offer me a bribe, and when I didn't take the bribe and reported it, get me out of the way, is because I was forcing Bain Capital KB to bid tens of millions of dollars for the eToys assets. So this meant that eToys was no longer insolvent, and then we could come out of bankruptcy. So they couldn't have that happen. So they locked me out of eToys, and then Paul Traub put in his long firm paid person, Barry Gold, who was also Paul Traub's partner, and both of them worked for Glazier and Bain in the Stage Stores case. And so now you got M&AT that works for Goldman Sachs and Bain, and Paul Traub, who works for Bain, and Barry Gold, who works for Bain, and Michael Glazier, who works for Bain KB, and of course Mitt Romney that owns Bain Capital KB. They're all pretending to be separate, but it's all one big organized crime, stealing from the eToys company. And so M&AT nominates Paul Traub, a Ponzi schemer who's partners with Mark Dreyer and Tom Petter's Ponzi, to be the one to prosecute Goldman Sachs. So in essence, in New York Supreme Court, Goldman Sachs sued Goldman Sachs, and eToys lost another billion like we did when we went public. And everybody's retaliating against me. M&AT's my attorney. After they confess lying under oath, the judge allows them to tell the court that the Haas affidavit, my affidavit, Laser Haas, that my Haas affidavit was a waiver of $1 million in fees and expenses. And again, who does that? You know, it's just a crock of crap. There's a legal standard called quid pro quo. What did I get for giving up that stuff? Nothing. And liars who confess to lying under oath. As a matter of fact, Paul Traub confessed to deliberately lying under oath. He deliberately left lies in there. The law, Henry Middleton Arms, that's ubiquitously adopted by all the circuits and affirmed by the Supreme Court and the Third Circuit, and even the very judge in the eToys case had already mentioned Middleton Arms and Henry Hazel Atlas Glass v. Hartford Empire, fraud on the court by officers of the court, equitably tolls the time. So when the lawyers the court approves to practice before it lie, and this is how much they lied. They asked the court not to let the eToys shareholders have an equity committee, which is allowed by law. The estate pays for it. M&AT, Barry Gold, and Paul Traub said that they had the eToys shareholders back. Yet M&AT destroyed books and records. Paul Traub and Barry Gold said nothing about it. They hid it from me, the guy that's running the company, right? I didn't find out about it until Sullivan and Cromwell's Jeremy Bates told me about it. When he told me about it, they let Jeremy Bates go. And then Paul Traub settled eToys versus Goldman Sachs in New York Supreme Court with Sullivan and Cromwell and M&AT and Barry Gold all agreeing that it settles for only $7.5 million, which is absurd. The New York Supreme Court just said we could sue them for billions. But they rushed to settle it to get it out of there so that nothing would happen about it. And the judge in the eToys bankruptcy case, I pointed out that she's letting fraud go on. She says, I'm not going to hear you. You don't have an attorney. I said, my attorney's sitting right there. M&AT, you authorized them to be my attorney. Authorize somebody else to be my attorney. You can't just turn around and say that you don't want to hear fraud because I don't have an attorney with me when the attorney you appointed for me is not doing their job. They're sitting right there in front of you. She says, I'm not going to hear you. I got to get back to Tweeter, right? I actually asked the judge in open record, who's in whose pouch here? And everybody cussed. And she said, strike that from the record. Well, the clerk struck all the cuss words from the record, but left my statement still in there. And again, it's obvious. This was the Chief Justice in the premier bankruptcy court of the United States, allowing these guys to break the law and giving them immunity. And she doesn't have the authority. Bankruptcy courts are not Article III courts, people, right? She can't give me a sanction for contempt of court. She can't do it. They don't have the authority. Now, she can rule that so-and-so be done, and the U.S. trustee and other people can go to enforce it and get district court to enforce it and U.S. Marshals to do it. But the Article III court doesn't have contempt of court powers, criminal court powers. They don't have the right to give immunity. As a matter of fact, 18 U.S.C. 30578 commands the bankruptcy judge to notify and refer the crimes to the U.S. Attorney's Office. But they knew that was a problem also, because they would have been notifying and referring it to Cone Connolly. That's the crooked prosecutor who was partner of the M&AT law firm I'm asking him to investigate and prosecute, who's already confessed to lying under oath. Come on, people. This is ridiculous. And they did this in Stage Stores. They did this in Petter's Ponzi. They did this in Mark Dreyer. They did it in the KB Toys case. M&AT represents Bain Capital of the $83 million that Michael Glazer paid them before they filed bankruptcy. And then Michael Glazer paid himself $18 million. And guess who was the prosecutor of that? Paul Traub asked to be the one to prosecute him. That's absurd. That's like Frank Nitti asking for the right to be the one to prosecute Al Capone. And instead, they threw me out of the case. We need justice, people. We need to stop this bullshit. We can make Bain Capital and Goldman Sachs go to jail. All we need is for you to get the word out.